All right, let's do this. Hello, everyone. Okay, welcome to today's webinar, Architecture in a Time of Pandemic, Professional Practice Issues and COVID-19. I'm Ingrid Spencer, Executive Director for AIA Austin and the Austin Foundation for Architecture. And this is the first in a series of open live webinars that AIA Austin will be offering. These will be open to all of our national AIA networks. You can find more about upcoming in the weeks ahead at aiaaustin.org. We're in unusual times, and it brings the opportunity for us to gather together online, and share valuable words and wisdom from our region with our larger community. Today, the wisdom comes from Allensworth and Porter with Matt Ryan, Honorary AIA Austin, and Whitney Knight, here to share their knowledge and help us navigate these troubling waters for our profession. I want to express gratitude to Allensworth and Porter for this, and Whitney and Matt for this presentation. Matt and Whitney have seen the questions that you guys have answered when you registered for today's webinar, and they've tailored their presentation to answer many of them. But at the end, there'll be a chance for you to type in some questions, and Whitney and Matt will address some of them. And you can always email me or them. We're recording this event, and we're gonna let Matt and Whitney decide if they wanna share the recording or just their slides. So thanks again for being here, and I'm gonna turn it over now to Matt Ryan and Whitney Knight.
Thank you very much, Ingrid, and thanks to everybody who's joined us here today. I've lost count. I think I saw approaching 90. We've got maybe double that as far as registrants. I want to thank all of you for tuning in. We're going to start by doing some introductions. Instead of the boring old lawyer self-introductions, Whitney has volunteered to subject me to a mini roast, and then I get to shower her with fanfare and adulation because that's the way things work around here. So go ahead, Whit.
Sure. I have the pleasure of introducing Matt Ryan today. I've known Matt for about 8.5 years. He hired me and has taught me almost everything I know in representing architects and engineers. He regularly represents architects and engineers in disciplinary and registration proceedings and defends them against claims and helps them maintain strong foundations in their business through his counsel. I feel very fortunate to be able to say that my mentor is the Best Lawyer's Lawyer of the Year of 2020. He's also an arbitrator for the AAA, is a professor of construction law at UT, and has served on numerous boards, including an 11-year stint at AIA Austin, where he is an honorary member. So for those of you who know him, he always has more to say than the time available, so I won't take any more time introducing him.
She waits and draws the longest knives out at the end. That was perfect. She charmed me into submission. So I've got a few things to say about Whitney. Whitney is my law partner. I'm very proud of that fact. She's homegrown, both in the sense that she's one of those rare native Austinites in this town of millions now. And she has spent all but her very first year of law practice at this firm. I believe that she writes the very best AE contracts that are available anywhere. So much so that many of my longtime clients, some of you in the audience, don't even bother to call me anymore. She's also the current treasurer of the Downtown Austin Alliance, and it will not be long before she rules this city outright. There's a small handful of moments in life that I've experienced where you can legitimately say that the pupil has become the master, and this is one of those cases. And so going against form, I'm going to go ahead and cut it off there and say Whitney is the best, and thank you for that very kind introduction. To launch into things here, I want to echo a theme that Whitney offered, and that is that we've got limited time and we need to get started right away with the real program. Whitney knows this, she just said it. Those of you who have known me for a long time know that I can tend to go real long. There's good news for you today because you're getting some relief from that. We're going to be crisp and fast so we can respect everybody's time and keep on moving. There'll be a couple of handoff moments on the screen when we're broadcasting, because we're broadcasting from different locations. So Whitney will seize control of the screen and move on, but please bear with us on that stuff. One other aspect of moving fast and having a lot to cover. Anybody expecting a deep dive into one particular area of coverage in the law is going to be very frustrated by this. There's too much we need to do. And this presentation is designed to shine a light on a wide array of issues that are going to confront architects and a lot of other design professionals. So I'm going to go to the second slide and do the obligatory thing of telling you that this is not legal advice. Not only do I do that so that I can protect my partners in this firm, but the fact is every contract, every project, every problem deserves its own solution, and those solutions depend on details. If you don't think details are important, you are not going to get good outcomes from your situations. We are, however, going to try and shine the light I was talking about on a whole lot of topics and contract clauses when it gets into Whitney's hands that we think will help architects navigate through some pretty dangerous waters in these weird times we're going through. So here we are, we're in the middle of a pandemic. Nobody's ever seen anything like this before. This is going to be the stuff of congressional investigations, literally thousands of articles and books that people are going to be writing, and we're right in the middle of it. Nobody knows how long this is going to go, where it's ultimately headed. The Final Four has been canceled, Wimbledon's off, the Olympics are off, most everybody's working from home. I'm in a different zip code from Whitney right now. And I will say construction has been declared essential here in Austin with projects now still underway. That's the majority of the people that I saw out on the street when I drove here around midday today to the office. The same is the case in other major Texas metros. Hassles from this come in all shapes and sizes. There are real life and death issues happening right now. So we do not want to be glib about this, but one side effect of things being shut down here in Austin is you can't even get a haircut anymore because it makes people too close to you. And so I'll say that the last time I was this shaggy was about 35 years ago, and I went to work looking like this. So feast your eyes on that and recognize that everybody could use a slice of humble pie every now and again. Richard Weiss, if you're out there, yes, that is a Magnavox. I went back and checked. All right, so for purposes of today, let's talk about our goals. We're going to be trying to anticipate things going wrong. We're going to try and deal with the things or prepare you to deal with the things that may get blamed on you, and maybe you can avoid blame altogether. We're going to take advantage of key opportunities to protect yourself, both through your existing contracts and the ones that you will draft in the future. And finally, we'll try and arm you with the information you need and the contract clauses you need to diffuse dangerous situations and keep them from mushrooming. Part of this is going to be, it's going to involve a walkthrough of some key contract provisions. When the real talent steps up and Whitney takes the mic and screen, she's going to walk you through some key provisions that are going to take center stage as we go through this mess and watch it unfold. Our hope and our goal is that pointing them out and demystifying them and talking about their potential operation will help you come out as successfully as possible as we work our way through this really confusing time. So we're going to dive in with segment 1 of 4 and talk about what Whitney and I thought would be a good list of things to do and what not to do as we go along. There's that voice in everybody's head right now that I'm quoting below about, what the heck do I do? The panic sets in when you think about what it is you can possibly do with these circumstances. Let's start by giving a voice to what can happen out there. Delays and inefficiencies are just the top. Team instability, both in size and availability of staff, illness and injuries, and illness leading to death. It's happening all around us. Job shutdowns and suspensions. We've already experienced some of that here in Austin, Travis County. Some job sites have entire trades, entire unions walking off jobs. I'd heard about that earlier this week. It happened, I believe, in New York. Job cancellations, which can be terrifying in their own right. The idea of jobs simply not happening, revenue drying up, unpaid invoices and unpaid consultants. What to do if and when the money's not flowing? How long will it flow? When is that PPP forgivable loan going to come through? And then that bolded language down at the bottom of the screen. Can you even perform under your contract under these circumstances we're living through? Everything is evolving in real time, and we are all bound to work on this together and try and roll with these punches. Pulp Fiction is one of my all-time favorite movies, so I had to start with a meme from that. I want to talk about what RTFC is and what it means and why it's so important and why we're starting with that. The PG-13 version of that, which Winston Wolfe would not have used, is read the freaking contract. You have to look at what the contract says the obligations are for the parties. The law coming out of the courts of Texas for the last roughly 25 years has been focused on the law of contracts. By and large, they're going to be read and enforced as written. This is the business world's way of allocating risks. It's why we have the economic loss rule to prevent everybody from owing a duty to everybody else. And so what you say you're going to do in your contracts, what you say the limits are of your responsibility is absolutely essential. But getting out of this lawyer speak and the economic loss rule, the courts are going to look at these risk allocation vehicles, these contracts, as the instrument, the prism through which everything is decided. And so you'll find that as a recurring theme today as we go along. Making a plan, it's one thing to quote Mike Tyson and say everybody's got a plan until they get punched in the mouth. This pandemic is one hell of a punch in the mouth. Nobody on this call or anywhere has seen anything like this. When we say make a plan, what we're saying is go from soup to nuts on this. Find your contract and read it. Find all of your sub-consulting agreements and read them too. And figure out what insurance policies are in play. Get a copy of those. Identify the known problems that exist right now, both at home within your own firm and outside your firm. Then engage in some advanced thinking about what you can do to stay ahead of the curve and beat those problems. What notices can you send out? Because that's a central theme of what we're going to be talking about today. What can you do now to avoid problems later? And how do you make a record of doing the right thing now, defending yourself, doing the things that your contract says you have to do and that the standard of care says that you have to do? That's what making a plan means. Papering up a record. Everybody can joke about it sounding just like a lawyer to say paper up the record. But literally some of the biggest problems that I've ever seen in my entire career have arisen from people who don't paper up the record contemporaneously when you're actually doing things. If you don't say it out loud, you don't make a record of what you're doing, you leave others with the later opportunity to deny that you ever did or said the right thing. So do it in real time as we go along. You'll also want to mind the gap between basic and additional services, figuring out where you are as far as what's in the basic block of services, what is beyond your basic scope. Architects know that. You get it in your gut. It's baked into your brains. You've read contracts countless times about that, but not everybody else gets that. I don't know too many people in life who like to get surprises. That very much includes owners, contractors, sub-consultants. You have to stay on top of things like your number of site visits, the number of RFIs, if that makes a difference in your agreement, anything else that counts. Keeping those records and papering it up along the way is the only way that you are ever going to get compensated if you want extra time or extra money or to be excused from performing what you have to do. So keep records of it. Whitney is going to be the master of this next topic when we get into segments 2 and 4. Negotiating better contracts. I know it sounds easy to say, but it really does make a huge difference. For years now, in giving speeches, I've referred to the things that get blamed on architects and engineers by extension. Those are crimes of opportunity. And if your contract is tight, you're going to very, very drastically limit the opportunities that people have to blame things on you and the potential downside. Say there's a limitation of consequential damages or a waiver, a limitation of liability, no damages for delay clause. All these things that fall into the 28 commandments that are at the end of these slides are going to be the subject of a nice deep dive in those slides and a moderately deep dive as we keep on going today. What to do on this list, wondering what to do in life for how to govern your project, especially if you see trouble brewing and you think that there's some kind of looming threat. Break the contract out. It's what nobody wants to have to do, but it is what you absolutely have to do in times like these. Insist that others do the same, because if they want you to live by the contract, you're going to need them to live by it too and figure out what's coming next. What not to do. Again, easier said than done. Don't panic, but panic's not going to make your situation any better than it is right this minute. We will take a deeper look at this second bullet point about not circulating internal guidance unless you want it to possibly be broadcast in a courtroom or in a deposition screen and get asked very deep and penetrating questions about it. Rushing into a solution, these times call for pretty quick action and decisiveness, but this is not the time to not think it through before you go do those things. And then don't do more than your contract requires. Architects that I run into, most of them are optimistic people. They're pleasers. I'm guilty of the same personality type. But remember to follow the scope and don't go in something that's not your scope, because it can lead to really, really bad results. Let's talk about sources of potential trouble. There's already quite a bit of talk afoot about performing construction phase services remotely. I don't know if that's through drones or through a FaceTime call, or by taking a laptop and saying, hey, go look out this window, or do you think that window has been installed the right way? That's tantamount to basically looking at the world through a series of keyholes and trying to decide whether something's done right or done wrong. It's got lots of different potential risks associated with it, and it's incumbent upon you to explain those things and pick out the details of any given project. They come in different shapes and sizes, different phases. There are different levels of importance: structural, load-bearing columns and walls and floors, things that really have to be seen, as opposed to different types of inspections. And we don't want to call them inspections anyway. We want to call them observations, but you got to call balls and strikes per the details that you're looking at. I don't know if too many people need to be reminded of a very narrow escape from a dreadful personal injury case from years ago. But that's the prism we should look at as we think about what the potential downside is for taking pictures and then saying, yeah, that looks built right, that doesn't look right. If you take a picture of that entire wall, we've talked to some clients about this already, are you comfortable with taking responsibility for that whole wall, all of its built conditions? In this case, with a balcony that fell down, what about the lack of bracing or blocking? Can you say that you expected that to be put in after that particular site visit? Maybe. Are those joints soldered that are circled or ovaled there? Did the contractor use long nails or lag bolts to really anchor those horizontal elements under the basket of the balcony? All these questions, you need to identify what you are and are not looking at as you go through your construction observation. And again, make some hard choices about what you will or won't go look at when you go. Another source of potential trouble leads us to another meme. You never agree in your contract to defend someone against coming claims. You will get to pay not just for your lawyers, but for your own. Your insurance company will say, that doesn't work for me. I didn't promise that, and that's not inherent in the practice of architecture. There's a certain amount of indemnity that Whitney can tell us about in a little bit that basically amounts to what's market. And so that to the extent you can wade into those waters as you negotiate your contracts, think very closely about this issue. Then there's the issue of serving as an initial decision maker. It's in the AIA forms. How far do you go on something like that? You are not an expert on impact and delay in projects, so you better think twice before you go ahead and say how much delay has been caused on a project. You may want to say whether something is adequately staffed under the project, and say that you'll go ahead and say that in general, according to the specific language of the AIA forms, that you can say, yeah, this pay app does appear to comport with the built conditions and the progress of the project. But questions about what's a concurrent delay, what affects the critical path, do not get too deep into that. And you may go ahead and decide to punt on certain issues. You may want professional advice on that. A really nice white paper issued by AIA National. It's open, available to the public. I did not have to log in to get this link. I strongly suggest you copy that link, click on it, and use that as a catalyst for some thinking. Um, Relief, instead of sources of trouble, let's focus on relief for a minute. Setting up a flare-on notice. That has been, I think, the topic of pretty much every webinar I've listened to, and I've listened to a lot of them as this pandemic has unfolded. Early and often, people joke about that being the voting rule in Chicago and New Orleans or wherever. But what you're really doing is what this second bullet point says, and that's providing the owner with greater knowledge. Be vocal about the proposed solution if that's within your lane as being the architect for the project. Think it through, make sure you're comfortable with going on record about it. But again, papering the record, advocating for yourself, and then hearkening back to what I said a few minutes ago, keeping records. If you're planning on claiming for time and money, you'd better keep the records yourself well. We could spend probably another day, day and a half exhausting the topic of force majeure and differing site conditions. Just know that because of what's happening right now and the inherent delays that are imposed by workforce, the way jobs have to be organized now, limits on crowd size, spacing for social distancing, there's going to be an absolute tidal wave of these coming. I expect to see force majeure argued about for the rest of my career. People are going to be looking to excuse their delays. There will be huge questions about whether the relief is compensable. Is it an excusable delay? Does it fall under what's actually listed in the force majeure clause? You have to look to the contract. Again, RTFC. Differing site condition. In a world where COVID-19 can exist on some construction surface for hours, maybe days, does that change what the site condition looks like and whether you can actually safely work in it? Questions about whether the equipment is even available to do your N95 breather masks. That may bring us into the world of impossibility, impracticability. These are all topics that could be the subject of much longer plumbs down various rabbit holes. When you look at what a differing site condition is, look to the AIA forms. They do a pretty good industry job, and there's a lot of thought that's gone into those. A few more slides before I hand off to Whitney. Here's some kind of top-level thoughts about things like claims and insurance and not bungling your way out of insurance coverage. There's an industry study that says that 2/3 of claims for professional liability, that is errors and omissions, against architects and engineers arise 2 or more years later than when the design services are actually performed. You want to consider getting a policy with an extended reporting period. And then if you've made that investment already to get the coverage, you might want to go ahead and maintain that investment. Think about the tail, about statute of limitations, the statute of repose. In Texas, it's 10 years. If you've made the original investment, you're planning on being in business. I've seen a lot of people later come to regret not carrying enough coverage in later years or just not carrying it at all. Literally earlier today, I talked to 2 people who are on the insurance side in handling claims, and they both very readily said that while there's a bit of a slowdown right now while people try and figure out the landscape around us, we do expect a bump in claims coming up. So that's probably the world we're going to be living in for some time to come. Corny little dad joke play on lead us not into temptation. My 12-year-olds will love that. But this is something that we've known for a long time. You cannot guarantee LEED certification. If you do, you're setting up trouble for yourself because there may be tax break implications, there may be certification issues that I've seen people try and sling around the neck of an architect. Some of those elements for certification are discretionary and definitely outside your control. It's one thing to put a bike rack in there and that gives you a point, but there are other things that are discretionary. So gauge it in terms of the standard of care and talk about reasonable efforts that you will undertake to make it happen. Here's one. You'll see that I did not do the distracted boyfriend, but rather the distracted girlfriend meme because we're woke here at Allensworth and Porter. The point here is don't ignore the red flag. When you face a temptation to swing for the fences and go for a project that you've never done before that you kind of don't know, disregarding signs of a troubled project or a client who looks like a hothead or somebody who's not going to be reasonable, having some kind of way to gauge those people. You can't predict the future, but I've had a lot of people post-2008, certainly post-2000 and 2001, who told me, man, I never would have taken on that particular client if they'd been swell times. So please think hard about the people that you're choosing to work with. If you do internal memos to your people, there is someone who's going to be dressed a lot like me or Whitney, who will be on the opposite side of you someday, possibly. And they're going to be able to find those things, and they will cross-examine you and yours and your experts about those things. All communications within the design team, except if they're with a lawyer or if it's in anticipation of a claim and otherwise privileged under the law, those things may be coming into evidence as well. So be careful about how you say things in-house. I've seen a lot of people hoisted on their own petard over that. So be careful what you say in that context. Money problems, liens occupies an entire class up at UT when we talk to the students about that. If the contract is directly with the owner, you do have to have a written contract, but compliance is relatively easy. You have to prepare a lien affidavit, file it in the county where the property is located. Timing of notices, if you're downstream, generally speaking, what the content of the affidavit, that is all very detailed and complicated stuff. So do not go in half you-know-whatedly on that deal, and know that there are no liens on public jobs. Contingent payment clauses, this gets you into the realm of what happens if you're not paid. You have to pay downstream. If you have the right contract clause and make it an express condition precedent, you may not need to until you get paid, but there's magic language underneath the types of clauses that we will write for those kinds of projects. And sometimes what sounds pretty good isn't quite enough to get you there. So those details matter as well. There's a Texas statute that qualifies the conditions under which you can impose contingent payment, but happily it doesn't apply to design professionals. If you're not paid, and we're wrapping up here, I have 2 more slides to go before giving this over to Whitney. If you don't get paid, don't be afraid to advocate for yourself through an instruments of service clause. I hope you have one in your contracts. If you don't, get one in there. If somebody breaches the contract first by not paying you for services rendered, that person has breached the contract, so you can start a conversation on that basis as well. On insurance, the first thing it says here is, when in doubt, report it. I've seen people make the mistake of not doing that. Just know that a claim is a demand for money or for services. Got to report that. You start hurting your prospects for keeping coverage. And why would you want to waive that if you've had the foresight and the investment to pay for a policy? If you have a claim, report it. What's not a claim, generally trust your gut. That some people call it loss prevention, circumstance pre-claim. You might be surprised at an insurance company's willingness to go ahead and pay for a lawyer to help you look at things if you get something like a subpoena or a deposition request or a document demand from you, and God forbid, a grievance at your registration board. Last slide before I hand it over to you, Whitney. If you fail to report a claim, you are probably going to walk yourself out of coverage if you give the insurance company a chance to say that you changed their position or injured their standing to help defend against the claim. And do not, I can't say this enough, do not ever promise something that you wouldn't have to simply do inherent in your architectural services for a project. Indemnity and defense beyond what we talked about up top, higher standard of care, best, all these superlative language items that you should never use. Never ever call yourself a fiduciary. That's the other F word in this line of business, and other things that we could go on forever. But Whitney, now it's your turn.
Okay, thanks, Matt. Let me grab the screen from you right now. Okay, that should be it. First of all, I want to apologize to all of you for the rotten timing of losing my voice right before this webinar. I'm fairly certain I'll be able to push through, but if not, I know that Matt's up for being put on the spot last minute to take over.
Don't do it.
So for this portion of the presentation, we are going to take a much deeper dive into the precise contract provisions that are likely to be at issue during this pandemic, and specifically those related to delays and the architect engineers or engineers remedies for delays. So the place to start is exactly where Matt pointed you to earlier in the presentation, which is read the freaking contract. I'll use the AIA B101 unmodified version as a basis for much of our discussion today. But you'll need to read your actual contract or talk to an attorney in practice. So first we'll need to understand what the contracts say about time and the timeliness of performance. So that's addressed in two separate provisions of the AIA B101. First, section 3.1.3, which deals with schedules, and also in section 2.2, which deals with the timeliness of the architect's services. On the schedule provision, first we need to understand whether there is an agreed schedule. Under the B101, section 3.1.3, the architect is supposed to submit a schedule for the owner's approval as soon as possible. The schedule includes not only dates for returning your design product, but also assumed dates for the commencement and completion of construction. And we'll talk about why that's so important in just a minute. Neither party is allowed to exceed the set schedule except, quote, for reasonable cause. And this theme of reasonableness will appear throughout our discussion today regarding the timeliness of the architect's services. Then, quote, with the owner's approval, the architect is to adjust the schedule as the project proceeds. So if your project is subject to a stay-home order, otherwise put on pause, or if there are actual delays as a result of any of the current circumstances, you must request an amendment to your schedule in writing to your client. It's pretty safe to assume that a project shutdown as a result of COVID-19 would constitute reasonable cause for a schedule adjustment. But that may not be the case for the epidemic generally in Austin, since most projects are allowed to proceed. That may be treated a little bit differently. So err on the side of caution, ask for a schedule adjustment if you need it, and do it in writing. Let's talk about force majeure for a minute. I'm sure you've all heard this word a whole lot over the last few weeks. It's a French word meaning superior force, and it's defined as an event or effect that cannot be anticipated or controlled. Generally, a force majeure clause will excuse the parties from performance if certain circumstances occur, but the clauses can take many different forms. One example would be a clause that lists out the categories of things qualifying as a force majeure event. We can see that in the DBIA standard form of general conditions here at 1.2.8. You can see here that it lists out war, floods, labor disputes, earthquakes. It actually anticipated epidemics. And it lists out those things that are qualifying events under a force majeure clause. Or a force majeure clause can take a broader approach, which would list out generally acts, omissions, events, or circumstances beyond the AE's control. And that would be probably a preferred approach for a design professional, because it wouldn't limit those events which could qualify as force majeure events, and therefore either excuses for performance or events qualifying for additional time or money. I've got another example of a force majeure clause up on the screen here, and this is a recommended force majeure clause for a design professional in light of current circumstances. It takes both the general catch-all approach, defining force majeure events as those delays caused by factors beyond the design professional's control, but it also lists out specific circumstances that may qualify, including infectious disease outbreaks, including but not limited to epidemics and pandemics. This one is tailored directly to the circumstances we're experiencing now. Note that this clause is one-sided. It doesn't allow your client or the owner to benefit from any force majeure events. Okay, let's talk about timeliness of performance generally. The unmodified AIA B101 agreement deals with timeliness of services in section 2.2. And it generally requires that the architect's services be performed as expeditiously as is consistent with the ordinary standard of care. So this template clause does not require the architect to meet any specific milestones. It implies that the architect has met its obligations so long as the performance is reasonably timely. Since we've never been in this situation, it's hard to say what is reasonable and what would be reasonably timely. But note that this is a separate obligation from section 3.1.3. So you'll need to be careful that you don't agree to unreasonable milestones in the schedule or guarantee unreasonable completion dates without accounting for events or circumstances outside your control. We've included a markup on an owner-oriented B101 that we've seen in practice, which requires the architect to perform its services consistent with the time parameters set forth in this agreement and as expeditiously as is consistent with the standard of care. So again, two separate obligations there. Speaking of guarantees on timeliness, time is of the essence clauses. The unmodified AIA B101 does not include a time is of the essence clause. They're not common in AE contracts, but they do exist. And we see them often proposed to design professionals by large national or international developers or owners. They're very common in construction contracts, unlike design contracts, and they often use the term time is of the essence in the performance of this contract. The effect of a clause like this is that it makes time a material requirement of the AE's performance, meaning that it makes it much easier for the owner to recover damages for delay from the architect or engineer. It really means that the owner doesn't have to prove that the failure to meet the schedule actually impacted the critical path. And so this is important for a number of reasons, but also because it can create insurability issues on your professional policy. I wanted to make a quick note. If you work on government projects, there's a section in the Texas Local Government Code at 271.904, which actually prohibits the governmental entity from precluding or from requiring timeliness of service different from the ordinary standard of care. So this type of time is of the essence clause, guaranteeing performance dates or timing other than the reasonableness standard is prohibited. So if you see a time is of the essence clause, look to see whether there's another provision that would excuse performance on the basis of things outside of your control. Here's an example of another time is of the essence clause from the DBIA forms. And then looking at the EJCDC forms, they treat time very similarly to the AIA. The engineer's performance must be reasonably timely. If there's a delay, not the fault of the engineer gets time and money. The EJCDC goes much farther than the AIA in the last section here, which says that the sole remedy for any delays against the engineer are direct damages only, which means that no consequential damages can be recovered for delay. And this is a big deal because most of the time, the largest set of damages suffered by owner developers will be deemed consequential. These are things like lost profits, interest carry costs, et cetera. And oftentimes consequential damages will also not be covered by your professional policy. So this is nice that the EJCDC addresses it directly in this clause. The AIA addresses it in a separate waiver of consequential damages clause that as the design professional, you always want to push to keep in your contracts. So now that we understand where to look to determine the architect or engineer's obligations for timely performance, we can look at what remedies the AE has in the event of a delay. Other than requesting an extension of time to complete, the AE is usually looking for one of two things: more money or termination or suspension of the agreement. So the first place we'll look is section 4.2.5 of the unmodified AIA B101. And it says that if the contract hasn't been completed within a certain number of months from when the parties sign the contract and the delay is not the fault of the architect, additional services are owed. Oftentimes this comes up in additional site visits due to an extended construction timeline. But that's not to say it wouldn't apply in a situation like we're facing today. Typically, the clock starts ticking on the date of the agreement. This is a common source of trouble for our design professional clients who change the date of the agreement after several months of contract negotiation and don't update section 4.2.5 to reflect the actual assumed schedule. Next up, how are your additional services paid? Just a quick reference to section 11.3, which allows the parties to fill in whatever manner of payment they deem proper, but often we will include something like hourly unless otherwise agreed by the parties, so that you get the benefit or the default of your hourly rates. Always request your additional services in writing. Section 4.2.1 requires prior written notice for all of the things on that list before you can get paid for the additional services. Sometimes you can provide them and ask for forgiveness after, but it's not the best practice unless you're trying to avoid delay yourself. And there's a second subcategory of items that you're allowed to proceed with before asking that are less relevant to our circumstances today. Notice provisions generally, 3.1.2 of your contract, if you're using an unmodified AIAB 101, will require you to provide written notice if there's any error or inconsistency in owner information. If the owner gives you a schedule with incorrect information, you must provide immediate notice of it. You also may owe notice to other parties. If there's a separate provision spelling out who to give notice to and by what means, you'll need to pay attention to those. But it may say that you need to provide notice by certified mail, return receipt requested. It may require notice by email. Pay attention to those notice provisions. And then what if you signed a lender's consent agreement? Those will almost always require any notice of default or request for a change in your agreement to be provided to the bank. A few other bases for requesting additional services that are relevant to the circumstances today. 4.2.1.1 allows requests for additional services for a change in information, including a quote, material change in schedule. This is why those design and construction milestones in Article 1 are so important, and they're often not filled out because when the contract is executed between the owner and the design professional, the schedules are fairly up in the air. So fill those out, even if it is an approximate date, and adjust them as the project proceeds. Section 4.2.1.2 allows additional services for services necessitated by the enactment of laws. I think the stay home order would apply to something like that. And there may be a reason to use some provisions over others. First, 4.2.1 doesn't have a requirement that the architect not be at any fault in the delay. This gets to the issue of concurrent delays, and relying on provisions like 4.2.5, which is the general extension of additional services for an extended schedule, may cause your client to invent some fault if they're really trying to avoid paying additional services. You know, if it says through no fault of the architect in 4.2.5, does that mean that if you cause a very small delay for failure to issue an RFI on time or respond to an RFI on time, that you can't recover any additional services? It avoids the disagreement on issues like that. But always, always, always ask as early as possible. And also remember that your consultants are likely going to be experiencing similar issues, and will also have similar remedies against your firms if you're working under a C401 agreement. So what if time and money aren't enough? Let's play this out in an unlikely doomsday scenario and think about what would happen if all of your projects were actually shut down for 6 months. Your firms would likely have to shed a lot of people. And when the projects restart, you may not have the bandwidth to pick back up and handle them immediately. There are several provisions in the AIA agreements dealing with suspensions, including section 9.3, which says that if the owner suspends the project for more than 90 cumulative days for reasons other than the fault of the architect may terminate. Savvy owners will often remove this clause, change cumulative to consecutive, or extend the number of days, because 90 can be reached pretty quickly, especially in a circumstance like we're in today. Note here that, again, it has to be for reasons other than the fault of the architect. And a really important thing to note here is if you're going to take advantage of a clause like this, you have to document the status of the project in the event of suspensions. And that's by asking for the schedule to be updated. Owners will also have a right to suspend in the contract most of the time. If the owner does suspend the project, there will be a question about what you're entitled to in the event of the suspension. Under the AIA agreement, the architect shall be compensated for services performed prior to the notice of suspension. And then when the project resumes, the architect is entitled to compensation for expenses incurred in the interruption and resumption of the architect's services. This is a clause that's very typically modified by owners and usually reverted back to just the amounts owed prior to the date of the suspension. Termination for convenience. Most owners will require the ability to cancel the project for no reason at all and without penalty. We call this a termination for convenience clause, and one is found in section 9.5 of the AIA B101. Occasionally, the architect or engineer will have this right also. It has to be added in on the AIA forms. But most of the time, your owner client's not going to want you to be able to walk away from a project scot-free in the middle of it, because that can put them in a really bad position on meeting schedules and other budgets. In the event of a termination for convenience, it's important to look at what you're owed in the event of a termination for convenience. Typically, it's for services performed prior to the termination, but it also, under the standard AIA B101, can include reimbursable expenses incurred and costs attributable to the termination, including the costs attributable to the architect's termination of consultant agreements. That's it's an addition to the new forms. Another clause that becomes really important in the event of a termination for convenience or a suspension under 9.3, the first clause we talked about, are the terminations and licensing fees. And a termination fee is really just a penalty for cancellation. It's intended to kind of liquidate the amount of damages that the architect will suffer as a result of the owner's unilateral decision to cancel. And it should compensate the architect for lost profits or missed business opportunities without actually saying so. And without the architect having to prove those damages, which are usually pretty difficult to prove. The licensing fee, on the other hand, applies if the owner intends to finish the project without engaging the architect to continue on. And so usually they're hiring a different architect or making the unwise decision to continue on through CA without an architect at all to save money. And it's intended to compensate the architect for its valuable intellectual property. It's far more common to see a licensing fee in an executed AIA agreement than a termination fee after negotiation. I'm going to briefly run through excuses for performance because I see we're running out of time very quickly. There are a couple of common law bases for excuses for performance and also some contractual bases. The doctrine of impossibility says that if it's impossible for you to perform your contract, you may be excused. There are questions about whether the stay-home orders or any project shutdowns by the government would qualify because usually under the doctrine of impossibility, performance is not excused if the unforeseen event renders performance merely economically burdensome, dangerous, or difficult, as opposed to impossible. Your contracts all anticipate delays with the time and money provisions, and so a several-month delay probably doesn't get you to impossibility. Instead, it's delayed completion. And the same goes for illegal acts. Courts generally won't enforce a contract provision that requires performance of an illegal act. So if it was illegal for you to show up on site, there may be a need to amend the contract to avoid that kind of excuse. Section 261 of the restatement sort of tracks this issue of impracticability of performance. Force majeure clauses are another reason that you may be excused for performance, as we've just discussed. Design professional breaches, you may see a lot more bad behavior from your clients in dreaming up fault to avoid payment obligations. And then contingent payment clauses, which Matt touched on. This just gives your client the ability to withhold your payment until he or she has been paid from some other source. So there are several reasons that your client, valid or otherwise, may have to withhold payment. And with that, Matt, I will pass it back to you.
Okay. Let's see if we can take this over. Do we now see segment 3 protocols?
Yes.
Good, thanks. I appreciate it. So we are short on time. We're going to try and race through the rest of these and remind you that these slides will be made available depending on how much post-production can be done and cleaning me up, making me look like a young Grand Moff Tarkin with technology. Maybe we can agree to have this program repeated and put out there. So we're going to talk next about protocols out in the field. Some of the questions that were posted in the registration process suggested that some folks out there think that there's an industry-wide lockdown, and in your market, maybe there is. Not here in Austin. Major Texas metros are chugging along as far as we can tell, but there still are protocols in place for how to deal with that. Looking at the different things that we think are good practice to put into motion, figuring out not just in-house, but downstream to your sub-consultants, what working from home looks like. You can't tell people, how to do their business. You never, ever want to mess with the construction team's means and methods. But you need to look, it starts at the very tip top with federal rules onto state, then county, then city. There are some industry standards that you got to stick with. Some of the issues right here are listed. The City of Austin Work Safe rules, because we're here in Austin, we're thinking about that quite a bit. So are a lot of our clients. Symptom protocols. We've got one having one for a job site. You don't want to take over a safety program, but have one for your home team and figure out what needs to be done and insist that a safety program be put, but be careful how far you tread into the world of controlling the safety program because you can immediately become responsible for that. So that is where angels fear to tread. You need advice on that, depending on what you're going to do. Digital tech like we're using right now. This is Zoom that AIA Austin is using. GoToMeeting has worked very well. Microsoft Teams has worked pretty well for us here internally. Lots of different ones. We all should have bought stock in those before this started happening. Temperature checks for arriving on site. Your own folks, you ought to be monitoring them and thinking about their safety and deciding what you can do to spare them unnecessary exposure to job sites and working under all of the WorkSafe protocols that exist. Making sure you're clear with the client about needing to space construction teams. Here, look at that all caps. Writing a compliance spec into your spec book that tells the whole team that the project has to obey. Participants in the project have to obey all these applicable standards that you've got there. And doing site visits maybe during off hours, that's not convenient. It might help you avoid being around a gang of other people. Depending on how things are going. I don't have direct contacts out into the market, but I certainly have heard some word about projects being overcrowded and violating rules, and some jobs getting shut down because of that. I haven't heard about anybody been put into jail for up to 180 days. I haven't even heard about any fines yet. But using care and making sure you adhere to these standards and insist on it within your own specs, all good things to be doing. Group size limits, the governor's order says no more than 10 in a group. 6 foot social distancing under OSHA. Model that good behavior yourselves, again, without monkeying with the construction team's means and methods. It says here in this little sub-bullet, trying to be a good steward for a project and not being a stitch or snitch. That's going to be a very delicate line to walk, but it's one that you're going to have to confront. Don't do it in isolation. Talk to your colleagues about it. Get advice. Think about what you need to do to comply with these things. Appropriate equipment. Whitney's taken us into the differences between impossibility, impracticability, things that are just economically more burdensome. You still have to go do it. Some things are completely not available. If you expect to get yourself an excuse for not performing because something's unavailable, you better be able to prove that it was not available. It's just the same as a weather delay or a force majeure. You've got to be able to show it. And in the case of a force majeure, it ought to be listed in your contract. Segment 4 takes us to the 28 commandments of architectural services agreements. I'm going to hand it back over to you, Whitney, to walk us through that, and hopefully we can blaze on through.
All right, yeah, I'm going to seriously abbreviate this section. and we'll try to get through it really quickly. I know many of you on the line have heard Matt's commandments before. And so you may be asking, why are we revisiting them? And some of you have heard them so many times that you remember when there were actually 10 commandments. Now we're up to 28. So we're mentioning them again because these are typically the most important clauses for assessing your firm's risk profile on a project. And when we're in times of trouble like this, it probably makes sense for your firm to categorize which ones of your projects are the most at risk of creating liability to your firm. So for example, a project in which your client signed a standard B101 agreement with a great limitation of liability clause will be much less likely to lead to liability on your behalf than if you signed an owner proposed form with no revisions. So we've been recommending to our clients that they create a spreadsheet with a list of ongoing projects and then categorize them by those that are in construction, and then the risk profile from the terms of the agreement themselves and anything unique about the project. We know that condo projects are inherently more dangerous, or maybe the client is particularly litigious, so that you can decide right now where to focus your most immediate efforts. And when I say immediate efforts, I mean proactively reaching out to your clients, opening the lines of communication to figure out how to get through these difficult times together. And it's always the best course of action to communicate. If you can get your client to go ahead and agree that site visits will be performed virtually through video conference or otherwise as an accommodation for the stay-home orders, even though your contract requires you to be on site, that's better than just folding your hands and stopping CA or dictating what will happen. So reach out to your clients, prioritize the most important, and the way that you would do that is through the client, the project type, and also whether you have these key clauses, like a limitation of liability clause that limits your liability to some amount within insurance coverage, but like hopefully less. Make it conspicuous. Waive consequential damages. We've talked about that. Disclaim delay damages and make sure there's no time is of the essence clause. Waive subrogation. The AIA has a great, the standard AIA has a great waiver of subrogation clause that you should start with. Avoid personal liability. Add a sole recourse clause, which says that your client's not going to bring a claim against you personally, only against your firm. Include a TBAE statement of jurisdiction. You have to include this statement in order to comply with the board's rules. The statement of jurisdiction is up on your screen now, but I'm sure you're all very familiar with it. Don't intrude into means and methods. Matt just talked a little bit about that. Define your scope of work. Establish what's not in your scope. Paper the file. Don't let there be unanswered bullets. You've all heard Matt talk about that before. Don't transfer your IP rights if you don't have to. As Matt mentioned, it's a really great thing to be able to rely on those intellectual property rights when things go wrong. Don't get behind on fees. Don't indemnify or defend your neighbor. Most of the time, those clauses aren't going to be insurable, but as Matt mentioned, there is a way to narrowly draft your indemnity clause to tie it to your proportion of negligence, which the professional liability carriers are generally okay with. Don't accept an elevated standard of care. We've talked a little bit about that. Never, never, never agree to be a fiduciary. You can wipe out your insurance coverage. Avoid betterment damages. Don't allow the owner to get a windfall from you. Select wise dispute resolution mechanisms, maybe arbitration, maybe litigation in some circumstances. It's very project dependent. Establish comparative fault if possible, and require a certificate of merit before claims can proceed. The Texas law requires them before a claim is filed in litigation, but we have a clause that we often recommend that requires the claim before the case can even be mediated. Disclaim third-party beneficiaries, and impose a severability clause, which means that if part of your contract is unenforceable due to some new law or new interpretation of the law, the rest of your contract survives. Refuse to name additional insureds. Your PL policy won't do that. Impose subconsultant flow-down clauses so that your subs are bound to the same extent that you are. And disclaim responsibility for project costs. Beware of condos. Disclaim input or advice on the selection of contractors. Disclaim a role in building science or building envelope expertise. And then most importantly, actually get your contract signed and make sure that it's approved through proper channels. So I know that was really fast, but wanted to get you all up and down in mostly in the footprint we agreed. So with that, I will turn it back over to Matt if there's anything else.
Okay, I was unmuting it because I was told that my computer was making all sorts of unwelcome sounds. A few words of conclusion. We've lost a small handful of participants because I know we've gone over time. We still got it in with about 5 minutes past. I want to say in conclusion, I've said this about architects a lot of different times. I said it in finishing my run on the board of AIA Austin. I consider architects, kind of my favorite people to represent in a lot of senses because I get it. We're trying to solve problems. We're trying to make the world a better place. And y'all are generally optimists by nature, and you like to get along with others, very much including your own clients. That is unquestionably a good thing as a general rule, but there are some hazards that come along with that in a time like this. And you need to resist the urge to accept blame or the responsibility for something that hasn't gone right. Do not cave in. Do not fail to defend yourself when the time comes. This is as important a time as any in your career for using your voice and availing yourself of what you've worked hard to build and what you've worked hard to negotiate into the contracts. Whitney said it, it's in the commandments. I've said it as many times as I think I've given speeches in my career. Leave no unanswered bullets. It leaves open the widest avenue for attack. If someone winds up coming after you, looking for an opportunity to blame you for something, remember that these things, according to that one study I cited, can come in 2 years or more after you've rendered your design services. Make sure that you paper things up along the way. Somebody says something untoward about you. The best example I can get is that somebody in a single letter years ago told a young engineer who was out of his depth and having a tough time, really struggling with a project, that he had lied to that owner about thing one, then about the original representation itself, followed by a third lie. That engineer had committed no such conduct, but he was so in over his head, he'd gotten so depressed that avoidance went into denial, and he just didn't deal with it. That became a policy limits proposition, that case, and things are never going to get better if you do not confront the issue sooner rather than later. Ultimately, we say this internally with our own little professional services shop, our firm, as we do to our clients. This is an opportunity to shine, to be helpful, and to be a good steward of a project or of a case, and to help your clients, which is what we signed up to do. Likewise, it's a chance for people on our own teams to shine and show the best that they can do rather than running for cover in fear. We all need to double down on what's happening right now. Queen Elizabeth said it best when she said, I think in a 4-minute speech, that we're going to get through this. We will. And even though no one can predict how it will turn out, we encourage you to ask questions. We've got a few here that I think we're going to try and deal with by using the technology in front of us. But I want to thank Rob Hoffman, Julia Brown, Ingrid Spencer at AIA Austin for making this happen lickety split. I want to thank all the attendees here. I think we may have answered some of the questions, but Rob, if you want to help walk us through some of these, I'm going to try and open this up as a dinosaur myself on technology. Let's see what we can do. Whitney, can you see these questions too?
I think I need to stop my share, but here we go. Yes, I've got them. So first of all, from Viviana Trevino, it says, are internal memos considered to be any written statements, or do calls, videos, Zoom meetings, etc. also apply? Matt, do you want me to take this one?
Yeah, you go for that one, far away.
Yeah, so it will depend on the scope of the discovery request, but savvy lawyers on the other side will ask for any forms of technology, and the logistics for actually recovering those types of things are a little more difficult, but you can assume that, especially given the fact that so much of our business is conducted digitally now, people will ask. We say internal memos because if you have your attorney on the video conference with you, or on the memo, the attorney sending the memo to your team, then likely it's going to be protected by the attorney-client privilege and not discoverable. So I hope that answers the question. Matt, do you have anything else to add?
One thing I'd add on top of that is you have to be very, very careful about what you create and have in the record within your firm by way of lessons learned type memos, things that are out there. Even if you've settled something, the ambit of discovery, and Ari Sklar, you've asked a couple questions here. I think we'll be able to deal with it here. Something that's discoverable simply means that in a later dispute, if it goes to a lawsuit or an arbitration proceeding, the other side can get hold of it. We live in an adversarial system of justice where each side is burdened with the task of putting on their very best case, and in many cases, making the other side, picking at their vulnerabilities to make them look the absolute worst. And so people will take those opportunities. If you've got a lessons learned memo, especially if it's just, full of all sorts of admissions of problems and what you need to do better, what you should have, could have, would have done, better to keep that stuff verbal. I've done it in some contexts where I've actually traveled to the home office and we've done a video seminar with remote field offices or other cities and whatnot, and walking through these things. Great opportunities to educate your folks, show them that you're aware of things and you're supporting the team that wound up with a claim, and that you're committed to not having that happen again, or addressing maybe some of the root causes, taking responsibility and holding on to your core values and advancing them. And so an internal memo, you probably, unless it is written by the lawyer, as Whitney says, you can probably expect that to be brought into the light of day if it comes through. What else have we got here, Whit?
I skipped a couple at the beginning from Ivan Contreras, and the questions have to do with city closing inspections, but giving the directive of approval through affidavit. The question is the architect obligated to perform the field inspections in lieu of city inspections, especially in regard to applications for payment? And then also, having construction still open in Florida, is it possible for an architect to refuse field services? I think the answer to this one is going to be very heavily dependent on what the contract says, and then what the state order or city orders say about staying home. And so I think it's going to be hard to answer that question without seeing that type of information.
I agree with that all. And I would add that this is a great opportunity for you to figure out what is and what isn't in your contract, because taking on, even the word inspections leads to higher blood pressure for people like me and Whitney and the people we work with, because you're not actually performing inspections, you're performing observations, hopefully in accordance with the qualifying language of industry forms that make it clear that you're not going to pick up on every error, and that things are covered up in the process of construction, and that you're going at such reasonable intervals to generally observe the progress of the work and observe whether there is general compliance with the plans and specifications. The word inspections takes you in a different direction and can be very dangerous. So words really matter when it comes to issues like that.
Okay, it looks like we have one more question from Gregory Neville. And permit drawings are trapped in the closed building department and cannot be retrieved at this time, or once the project is finished, it cannot be submitted for permit plan review. What is the best way to document this, and how does this affect our exposure for delays? I'm not sure what jurisdiction this is in. I've heard rumors of, the ability to submit things virtually right now, but let's assume that there really is no way to get the permit drawings, and nothing can be submitted for permit plan review. Those are absolutely the types of things that we would recommend going ahead and bringing to your client's attention immediately, asking for an adjustment in your schedule, explaining the reasons, and going ahead and getting the extension of time for these unforeseen events.
I agree with all that. Nothing to add to that one. That was a perfect answer.
Thanks.
Friends at AIA Austin, is there anything that you would like to offer in closing here?
I do want to mention that once you close the webinar, you will get a survey, just 3 questions, what you thought of this seminar, but then also topics for future seminars. So we would appreciate it if you would fill that out.
Please be gentle.
Yes, please.
Okay. Thank you again to our friends at AIA Austin for putting this up and making it work so unbelievably smoothly. This is a real glimpse into the future. We appreciate y'all paying attention, and we invite questions coming through on the side of this. There may be different forms of this seminar being taught again, so please Let us know your questions. Let us know what we can do better and what was helpful. And let's all push on through this together.
All right. Thank you very much, Matt and Whitney.
Thank you.
Thank you.
Bye-bye.
Bye.